I knew something was off the moment they changed the lock codes without telling me. I wasn't fired, not officially. My badge still worked. My desk was still there. But suddenly, I couldn't access the server where I'd spent 6 years building the backbone of their federal risk engine. The air smelled different too, like something sterile and expensive had replaced the quiet chaos we built. I heard laughter coming from the executive hallway. A new voice. Male. Loud. Marketing handsome. It took one look at his shoes, pointed leather, no scuffs, to know he didn't code a single damn thing in his life. But people like him don't need to. They arrive with buzzwords and PowerPoints and slowly begin replacing the foundation with foam bricks painted to look like steel. My name is Brian Kroll, but at work, they called me Brian. Easier that way. Most of the men didn't want to believe I was the architect behind the engine that landed our first federal contract. They preferred to think I was some assistant to a ghost coder. Let 'em. While they preened in investor calls, I built hash chains, filed encrypted documentation, and quietly printed off hard copies of every version lineage into binders no one asked about. And when the merger whispers started swirling, new logos mocked up in the design room, HR avoiding eye contact, I started notarizing things, quietly, methodically. Every feature map, every system log with my name on the change record. If you've made it this far, do me one quick favor. Subscribe and tap that like button. You'd be shocked how many people listen without subscribing, something like 97%. But it helps more than you know, and yeah, it keeps our team caffeinated and vengeful. Thanks. They didn't realize what I'd done until much later. Back then, I was just the girl who ran the compliance layer. No one looked twice when I started walking home with file folders in my tote bag. After all, they were just paper, and we were a cloud-native company now. Never mind that most of our systems were duct-taped together with proprietary wrappers I personally patched after their flashy new hires tanked dev sprints with demo-ready garbage. The changes started small. My edit permissions vanished on Git. Admin logs stopped recording my commits. One night, I tried to submit a patch and got bounced out by a security flag I'd written myself. When I opened the log to check what rule was triggered, the file was blank, not corrupted, wiped. And that's when I knew someone wasn't just nudging me out. They were rewriting the record. That same week, a request came in from legal. Just standard IP review, the email said, signed by a paralegal I'd never met. They wanted confirmation of contributor names on 3 modules. 3 I designed from scratch, ones I hadn't even let interns near. I didn't reply. Instead, I opened my safe at home, pulled out the notarized origination sheets from 2 years ago, and scanned the paper signatures into a separate encrypted drive, one that lived on a zero-access machine. I told no one. I smiled through stand-ups. I nodded when the new VP, Graham Dorsey, wandered into my project review and said things like synergy and modernized legacy tech. He never once asked what the code did. He only asked what it looked like to investors. And that, more than anything, told me everything I needed to know. They thought I'd go quietly, that I'd fold like the others, that I'd vanish under the weight of some HR-manufactured realignment. But I don't fold. I document. And if they wanted to play games with federal compliance software, I was happy to let them, so long as they understood I wrote the rules. Graham Dorsey showed up like every LinkedIn thought leader's wet dream. Tailored blazer, smug optimism, and a handshake that felt like a sales pitch. First day on the floor, he called in all hands and opened with, "I'm here to disrupt the way we think about value." That was code, not the good kind. It was code for gutting whatever didn't sparkle under fluorescent lights and replacing substance with spectacle. And the worst part? Everyone clapped. I watched him glide past the dev bullpen, nodding at monitors like he could read code through osmosis. The interns loved him. Marketing swooned. HR practically genuflected. The man had no technical depth, no historical context, no idea how brittle our stack really was. But he had buzzwords and teeth. You could almost hear the venture capital flowing behind him like a wind tunnel of bad decisions. 2 days in, he started renaming teams. Data integrity became growth signals. Legacy systems became tech debt recovery. I went from lead compliance developer to something called workflow hygiene consultant, which sounded less like a title and more like a polite way to fire someone with hand sanitizer. He'd never built a single protocol, but he talked about restructuring as if our code base were a fashion line one season away from irrelevance. Then the calendar invite came. Subject line, performance calibration review, private. No location, just a time. I showed up early. Bad habit. Sat outside the executive conference room watching my reflection in the black glass while the clock ticked 1 second past the hour. When the door finally opened, it wasn't HR inside. It was Dorsey, alone, arms folded, iPad on the table. He didn't sit. "Let's make this simple," he said, like he was doing me a favor. "We're realigning around velocity. Some of our legacy folks just don't fit the new trajectory." I didn't speak, just stared. Let him fill the air with his own noise. "Your severance package has been reevaluated," he added, tapping the screen. "Given the concerns noted in your last 3 sprints, concerns around adaptability and collaborative friction, legal has deemed severance non-mandatory. You'll get final pay, but no extension." I knew what this was. Manufactured performance issues. No documentation. Just enough corporate lingo to imply I'd been the problem all along, and if I protested, they'd accuse me of being difficult. Bitter. He slid a folder across the table. NDA, non-disparagement clause, no-fault termination waiver. Just sign here, and we can process the exit cleanly. I looked at the pen, then looked at him. No. He blinked. Not confusion, surprise. People like him expect compliance, not defiance. "Excuse me? I'm not signing anything without counsel," I said, rising. "You'll get a response through proper channels." I walked out before he could reply. My hands didn't shake. My voice didn't crack. But inside, I was on fire. By the time I reached my car, I'd already started mentally cataloging every feature I'd ever authored, every timestamp, every change request, every bug fix I'd submitted that Dorsey's golden boys failed to resolve. I wasn't just fired. I was being erased. But here's the thing no one teaches in business school. Ghosts don't scream. They document. I wasn't angry. Not yet. Anger's a waste. I was calculating. They wanted to sever me from the code? Fine. But they'd better pray to every non-denominational tech deity that I hadn't kept records. Because if even one federal contract could be tied to falsified authorship, Dorsey's optics wouldn't just blur, they'd shatter under audit. I didn't sleep that night. I organized, I indexed, I ran integrity checks on every signed log, and for the first time in months, I pulled out the copy of the state's revised business code I'd printed just after they changed the IP clause. Section Paragraph 48, 11, 3 paragraphs, 1 bullet point, clear as daylight. No non-compete shall be enforced absent authenticated authorship transfer of intellectual property. They thought I was a shadow. That I'd vanish. But shadows don't vanish. They follow. The envelope was thick and smug. Certified mail, corner-stamped with the company's new rebrand, like they couldn't wait to tell the world they were burying the past. I already knew what was inside before I slid it open. They didn't even have the decency to email me. Paper burns slower. Cease and desist. Effective immediately, I was barred from engaging in any form of technical consultation, software development, advisory input, or systems design, basically anything with a processor and a pulse within a 12-month radius of my own expertise. The kicker? They cited risk of intellectual contamination, as if I were some walking biohazard of trade secrets. I read it 3 times. They invoked the non-compete clause with language so broad I half expected it to ban me from owning a laptop. I wasn't just out. I was muzzled. Outlawed from using the skill set I'd built over 2 decades because some posturing VP decided I was dead weight. And then I saw it. Buried in the footnotes under Exhibit B, a list of patent continuations recently filed with the USPTO. Familiar titles? Very familiar. Module enhancement for dynamic risk evaluation. Secure fork of predictive compliance tree. Real-time threat classification layer. RTC layer v2. All of it mine. Built across lonely weekends, buried under caffeine and silence. I remembered debugging that RTC branch while my mother was in hospice. I remembered the exact timestamp on the commit log because I'd cried when I pushed it. It wasn't just code, it was lived memory. And now it was theirs, filed under the company's name. No co-authors, no acknowledgements, my name nowhere in sight. I didn't throw the envelope. I didn't cry. I sat down at my dining room table, pulled out my legal pad, and started listing everything I'd ever submitted, every signature, every paper trail. Because here's the dirty secret about quiet people. We remember everything. Dorsey thought he'd neutered me. He thought a flashy IP filing and a boilerplate gag order would keep me locked out while he polished his exit package and showed off my work in some investor deck. But what he didn't know or didn't bother researching was that 6 months ago, the state revised Paragraph 8.11 of the Business Code. It was quiet legislation, no fanfare, just a surgical clause slipped in by a few good lawmakers who still understood that knowledge workers aren't disposable meat. The amendment made it clear. Non-competes were unenforceable if IP had not been properly assigned, with documented, signed, and authenticated authorship. No assumptions. No silence equals consent. Paper or perish. I had the paper. Better yet, I had the chain. Logs notarized quarterly. Signed documentation of every author-originated file. I'd been filing them privately for years, partly out of habit, partly because some instinct told me that one day someone would try to ghostwrite my life. I didn't tell anyone. I didn't post about it. The worst mistake you can make in a storm is to raise a flag before you've finished building your boat. Instead, I hired a lawyer, not a friend, not a family referral. I found a woman named Farah Cho who'd written 3 amicus briefs on employment retaliation and whistleblower IP fraud. I sent her a single email. I've been named on nothing, but I've authored everything. I have the proof. The question is, do I have a case? She replied within an hour. If you're telling the truth, not only do you have a case, you may be the first test of Paragraph 48.11 in our district. Let's schedule a consult. Do not speak to anyone else in the meantime. I poured myself a drink that night. No celebration, no relief, just a single pour of good rye and a hard look at my own reflection. I felt humiliated, violated, like someone had reached inside me and rewritten the last 10 years in Comic Sans. But I wasn't broken. I wasn't even angry. I was patient. Because if they thought the muzzle would hold, they'd forgotten one thing. I built the walls they now tried to cage me with, and I knew where every brick was cracked. Farah didn't waste time with pleasantries. The moment I sat down in her office, more case files than furniture, she slid a copy of Paragraph 48.11 across the desk and said, "If what you're saying is true, they just pulled the pin on their own grenade." I didn't smile. I didn't blink. I just nodded. They never got a transfer agreement, I said. Not for the origin files, not for the root builds. All they had was my contract, which doesn't include mandatory IP turnover clauses for independent author modules. She leaned back, tapping a pen against her lower lip. Let me guess, they counted on inertia, maybe even fear. People like you, heads down, loyal, quiet. They assume you'll never fight back. They assume silence is compliance, I said. And that, she said, flipping open a legal pad, is where they're wrong. Paragraph 48.11 was elegant in its simplicity. The amendment, effective as of 6 months ago, clarified that non-compete agreements could only be enforced if a company had a signed, authenticated transfer of intellectual property for the work in question. No signed transfer, no muzzle. It didn't matter what your badge said. It didn't matter if you built it on company time. If your name was on the authorship log and you never handed it over officially, they couldn't leash you with your own mind. We spent 3 hours going through my files. I brought 2 banker boxes and a drive with a nested archive of time-stamped development logs. She scanned a page at random. RTC Layer V2 commit hash dated 2021 attached printout of my signature from the quarterly attestation cycle. Notarized. She looked up. Do they know you have this? I shook my head. They think I walked out with a mug and a bruised ego. Farah grinned like a woman who'd just smelled blood in the water. Good. Let's keep it that way. The next step wasn't courtroom drama. It was methodical silence. We prepped. She filed the intent to challenge the non-compete. We drafted the counterclaim under whistleblower retaliation, flagging misrepresentation of authorship in documents tied to federal bids, something that, if proven, could trigger not just civil penalties but contract suspensions. I didn't want to destroy the company. That's the part no one understands. I built that engine. I believed in it. I believed it could help. But watching it get weaponized by people who didn't know a socket from a script, that was the betrayal. And Graham Dorsey? He wasn't just trying to erase me, he was trying to sell me, my work, my name, my history as his product. Farah warned me it wouldn't be quick. We'd need to wait for them to blink. She called it legal chess, but I didn't care for the metaphor. Chess implies two players with equal rules. This felt more like a rigged game of poker until I remembered I'd marked the cards, so I went home. I labeled more files. I wrote affidavits for each feature I designed, cross-referencing version dates with internal emails and timestamps. I pulled screenshots of commit logs from my personal archives, ones stored offline, never touched by their VPN. I wasn't angry anymore. I wasn't even afraid. I felt resolved, like a machine set to a single instruction. Preserve truth. Let Dorsey posture in meetings, let them file patents with my ideas, let them tell shareholders they had it all under control. Because I had the one thing none of them understood how to fight. Paper. Real paper. With wet ink. With dates and stamps and margins scribbled with notes made long before Dorsey even knew our name. Revenge wouldn't come with shouting or slamming doors. It wouldn't be some grand cinematic takedown. No. My revenge would be notarized, initialed, and filed with the court clerk under seal. They filed first. Of course they did. A thick packet of legal muscle stamped with urgency and dramatics accusing me of material breach, potential IP dilution, and my personal favorite, malicious circumvention of ethical post-employment limitations. It read like a badly ghost-written thriller, right down to a paragraph about how I posed measurable reputational risk if allowed to operate in a similar space. What they didn't know was that Farah had already pre-filed our response. By the time their paperwork landed, ours was being processed, counterclaim under Power 48.11, plus a motion to invalidate the non-compete and an attached affidavit flagging potential IP misrepresentation to federal procurement. Dorsey's side made noise. PR safe statements, leaked to Tech Pulse, something rogue developer. My phone buzzed with ex-colleagues asking, "You okay?" Like I'd gotten mugged, not railroaded. I said nothing. Not out of weakness, but precision. When the plane's on fire, you don't scream. You check the parachute straps. The court date was set. Civil docket, expedited hearing 3 weeks out. Farah called it unusually fast. They want it done before the merger closes, she said, eyes flicking over another glossy printout of the upcoming sale announcement. They need you out of the way, quiet and gagged. Depositions started in a conference room downtown that smelled like dry toner and institutional panic. Their counsel brought a junior litigator and a smug man in a blue suit who kept trying to shake my hand like this was a negotiation. I didn't shake it. They started with questions about my role. How would you describe your contributions? Farah cut in before I even opened my mouth. We'll refer to the documentation. The junior frowned. We're just trying to understand Mr. Krall's perspective. His perspective, Farah said, sliding a binder across the table, is in there. Authored, signed, notarized, and time-stamped. 324 pages. Indexed. Page after page, module outlines, version logs, signed feature specs, QA integration notes in my handwriting. Every bullet point lined up with system records they thought were lost to time. That binder didn't shake. But Dorsey's team? They did. Especially when Farah pulled out the discovery packet. Emails scraped from internal servers during the compliance window. One stood out. From a senior PM to Dorsey himself, dated 6 days before I was cut loose. We can't delete Krall's name from the author log unless we fork the base layer. Legal said it's risky unless we can prove reassignment. Dorsey's reply, do it quietly. Perception matters more than paperwork. Merge it under ops. That email sat on the projector screen for a long, long moment. The room got still. The man in the blue suit asked for a recess. Farah declined. We kept going. Deposition after deposition, my name kept surfacing like a signature in invisible ink on every dev list, in every bug fix comment thread, at the top of every alpha push. It wasn't a job. It was authorship. And Dorsey? He hadn't written a single damn line. I barely spoke through the whole thing, just sat there, hands folded, watching the story shift from non-compliant ex-employee to unacknowledged builder. Every time their lawyer stumbled, I just flipped to the next tab. The truth didn't need drama. It had timestamps. At the end of the third deposition, the lead counsel on their side said quietly, "We weren't aware of the full extent of Mr. Krall's documentation." Farah smiled like a cat that had already eaten the canary and filed the feathers. "Now you are." They wanted a ghost. They got an archivist. And I was just getting started. The courtroom wasn't packed yet. Pretrial always draws less attention. Just a smattering of attorneys, board clerks, and the occasional executive who thinks they're still 10 feet tall behind a corporate badge. But Graham Dorsey showed up in person, navy suit stretched across ambition and arrogance like a trophy case he wore on his back. He didn't look at me as he took the stand. Just straight ahead, confident, rehearsed. His testimony started calm, smoothed over timelines, carefully sanitized descriptions. He described me as a support contributor, a role he claimed was mostly administrative. Mr. Krall handled compliance and documentation and configuration hygiene, valuable, of course, but not what we define as authorship. I didn't move, neither did Farah. He went on. Said the code base was a collaborative effort, that ownership of intellectual product resides with the company, and that my output was meaningful, but non-original. That word, non-original, like I was a cut and paste function in human form. Farah stood without a word and walked over to the table where our exhibit sat, arranged like a patient autopsy. She selected a binder and a flash drive. No drama, just method. "Your Honor," she said, sliding both items onto the bench. "Defense would like to introduce Exhibits 17A and 17B. These include notarized development logs, signed authorial feature maps, and SHA 256 hash certificates for all core modules in question, time-stamped more than 2 years before the company filed its patent continuations." The judge adjusted his glasses, scanned the documents, looked up. "Counsel, have these files been independently verified?" "They have," Farah replied. "Third-party checksum validation and 2 state notaries included in the appendix." Then she clicked the remote. Projected across the courtroom wall was a snapshot of one of my original logs, line after line of clean, functional code, my initials stamped at the top. Date: July 13th, 2021. Then she flipped to the next slide, Dorsey's own email. "We can't file with Krall listed. If we clean the author metadata before the merger closes, legal says we'll be in the clear." Next slide. A Slack message chain between 2 project managers. "We're scrubbing him from Jira this week. Don't flag it externally. Dorsey's orders." The room didn't explode. It froze. The judge looked over his glasses at Dorsey. "Do you still stand by your earlier testimony regarding authorship?" Dorsey's jaw twitched. His tongue pressed against the inside of his cheek, like he was trying to find a version of the truth that hadn't already bled out on the courtroom wall. Farah didn't wait. "Your Honor, we would also like to submit a chain of custody certification that tracks these files from origin to present, including offline backups and attestations from the federal procurement officer who reviewed them during initial contract validation." Dorsey's attorney objected. The judge overruled. It was over. Not officially, not yet. But the trap had closed, silent and airtight. I hadn't taken my eyes off Dorsey once. And finally, after all this time, he looked at me. He didn't glare, didn't smirk. He just searched. Maybe he was looking for anger, some righteous fire, maybe even a smile. But I gave him nothing. Not a word, not a blink. Just the stillness of a woman who had already buried the man in front of her, on paper, in ink, under seal. He shifted in his chair, spoke no further. The courtroom stayed silent. And I sat there, every document pristine, waiting for the next lie to collapse. The judge was silent for a long time, not the kind of silence that comes from confusion, but the kind that comes when someone already knows the answer and is just deciding how hard to say it out loud. He closed the folder, adjusted his glasses, and looked first at the exhibits, then at Dorsey, and finally at me. "Mr. Dorsey," he said evenly, "can you confirm whether any intellectual property assignment documents were signed by Mr. Kroll for the development modules your company filed patents for?" Dorsey shifted in his seat. His lawyer cleared his throat like he might conjure a form out of thin air. "Your Honor, we believe that the employment contract covers implied transfer of work product. That's not what I asked." The judge cut in, voice low but sharp enough to slice through granite. "I asked if you have signed IP assignment documents for the origin files, specifically." A beat. Then Dorsey, arms folding tight, muttered, "No, Your Honor, none that we've located." The judge nodded once, like he'd already written that answer in the margin. "Then let the record show, under current state law, amended under Section Paragraph 4811, a non-compete clause cannot be enforced where no valid IP transfer agreement exists. Employment alone does not constitute authorship reassignment." No one moved. Even the stenographer stopped clacking keys for a second. The judge continued, his tone unchanging but final. "Therefore, the plaintiff's claim to enforce a non-compete against Mr. Kroll is hereby denied. The clause is void under state statute. This court recognizes Mr. Kroll as primary author on record unless contradictory. Signed evidence is submitted." It wasn't a hammer blow. It was something colder, surgical, and worse for Dorsey because it wasn't theatrical. It was just done. I heard his lawyer lean in, whispering something sharp and fast, too low for the mic. Dorsey's face had drained of its usual varnish. His collar suddenly looked a size too tight. His hands, so animated during his grandstanding, were now flat on the table, fingers splayed like he was trying to hold on to the surface beneath him. I didn't move, didn't smirk. I just sat there, still as ever, let them squirm under the weight of paper and protocol. Farah closed our binder with a quiet thud, as if sealing a coffin. She didn't gloat either. That's not our style. Victory doesn't need applause when the floor is littered with their own exhibits. It was subtle, but I felt it. The energy in the courtroom shifted. Suddenly, I wasn't the accused. I wasn't the disgruntled former employee. I was the origin point, the one with the receipts, the one who hadn't flinched. And Dorsey? He wasn't just wrong, he was exposed. He looked at me again, eyes wide this time. And I stared back, that quiet flame behind my eyes flickering steady and blue. I hadn't screamed. I hadn't begged. I hadn't swung a single punch, but they felt every hit. Because when you erase a name, you better make damn sure it was never carved in stone. And mine was buried deep in the foundation they were now standing on, cracked, shaking, and ready to fall. The judge didn't raise his voice. He didn't need to. He simply leaned back in his chair, folded his hands over the binder, and said, "We have one additional matter pending, Mr. Kroll's counterclaim regarding federal contract misrepresentation. Before we proceed, I'd like to make one point clear." The room hushed, not the theatrical silence from movies. This was the kind that presses on the chest, like waiting for a fire alarm to go off. Any misrepresentation of intellectual property authorship tied to federal procurement filings, the judge said, is not merely a civil issue. If proven, it may constitute a violation of Title 18, Section 1001, false statements to the United States government. I trust all parties understand the gravity of that. You could feel the temperature drop. The judge didn't wait for an answer. He simply turned to the court clerk. "Let's pause here. Counsel for the plaintiff may wish to reassess their position before we proceed with counterclaims." That's when I saw it. Dorsey's lawyer, face pale and clammy, scribbling a note on yellow legal pad with hands that had suddenly forgotten their confidence. He shoved it across the table toward his client. 2 words. "Settle. Now." I didn't react. I didn't even look at them. Just stared ahead, still and silent, as their empire of fabricated confidence began to fold in on itself like cheap drywall. Farah didn't gloat. She just gave a small nod and began organizing the binders into stacks, like the trial was already over and all that remained was cleanup. We left the courthouse without fanfare. No cameras, no applause, just the soft click of heels on marble and the weightless quiet of truth doing what it always does, eventually surface. 3 days later, news leaked that the merger was delayed indefinitely. But those of us who watch the way deals die knew the truth. Their buyer, the firm that had once drooled over Dorsey's flagship platform, quietly walked away after requesting internal documentation and realizing the foundation they were buying rested on forged credit. That same week, I signed a contract. Not with just anyone, with their rival. The company Dorsey once mocked in boardrooms as outdated. The offer was generous. Advisory role, full autonomy, patent rights respected and filed under my name, retroactive attribution on all modules we'd build forward. They didn't ask for drama. They wanted resilience, clean systems, real authors. I gave them one condition: no PR, no splashy announcements, no headline making it look like a poached trophy. Just work. Just truth. They agreed. So I walked into a different office weeks after they tried to lock me out of the entire industry. No parade, no welcome banners, just a new badge, a clean slate, and my name exactly where it belonged, at the top of the commit log. I wasn't angry anymore. I wasn't satisfied either, not in the way movies sell you, where revenge ends with champagne and tears. It was quieter than that. Cold, precise, like a circuit finally completing its path, like silence you could sit inside. And that was more than enough. It took months, not years, not decades, just months, for the truth to do what it always does when given enough room: reappear in ink. A new filing hit the U.S. Patent Office one crisp Monday morning. Clean header. Proper chain of custody. Encrypted development log hashes matched line by line. And under author of record, in all caps, clear as a scalpel incision, Crawl, Brian R. No company name, no co-authors, just mine. The day it went through, I didn't celebrate. I didn't even leave my desk. I read the notice once, nodded, and kept typing. The code didn't stop needing me just because the credits finally caught up. A week later, my new firm, lean, brutal, efficient, secured a 5-year federal contract using the same core logic I'd built in the shadow of a place that once called me redundant. This time, the paperwork had no ghosts. Every author tagged, every timestamp aligned, every ounce of compliance built from stone, not spit and spin. They called us Crawl Systems. I didn't pick the name. The partner board voted on it without telling me. You earned it, they said. Time they remembered whose hands built the bones. Meanwhile, the company that tried to bury me dissolved the scandal like corporate bodies always do, quietly, cleanly, with words like strategic pivot and executive transition. Dorsey resigned before Q3. No public statement. Just vanished. The board spun it well. They always do. But they stopped talking about the risk engine. Stopped pushing the merger. Stopped whispering about innovation like it came from whiteboards and coffee breaks. And me? I kept building. Kept signing only what I authored. Kept my logs, my notebooks, my paper trail. Because in the end, it wasn't rage that saved me. It wasn't protest. It was the quiet resolve to be undeniable without ever raising my voice. Funny. Funny how a man under a muzzle could bring the whole room to silence.